Hello and welcome to a new CM Murray 10-minute talk where myself and my partner Beth Pale will be talking about a new piece of employment legislation which is imposing duties, quite onerous duties on employers. Morning Beth, how are you?
Good, thank you. How are you?
Good, thank you. I'm excited to be talking about this piece of legislation. It comes under the Worker Protection Amendment of the Equality Act, comes into force on the 26th of October 2024 and imposes new duties on employers to take reasonable steps to prevent sexual harassment in the workplace, which means that unlike the existing obligations on employers to prevent sexual harassment or to take steps to prevent sexual harassment in the workplace between employees, it now means that employees and workers can expect the employer to take reasonable steps to prevent sexual harassment by people outside of the workplace who they come into contact with, such as clients and customers. Exciting to be talking about this because it's quite an interesting piece of legislation which employers will need to be getting to grips with, however big or small they might be. I think in the first instance, Beth, it might be helpful, if you don't mind, just explaining what sexual harassment is, because it's the duty only applies to sexual harassment, doesn't it?
Many of you watching this video will know what sexual harassment is, but just by way of recap, the Equality Act 2010 sets out the definition of sexual harassment, and it is unwanted conduct of a sexual nature which has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. And it can involve a physical act, can involve a verbal act, non-verbal acts. It's pretty broad, and one single act can obviously be an act of sexual harassment. I think what's really interesting about this new duty is, for the first time, really, it's imposing an obligation on employers to view sexual harassment as a sort of a front-end issue rather than after the event litigation risk, or after the event sort of taking appropriate action. Taking appropriate action and being seen to take appropriate action, as we'll come on to, will be a key part of compliance with the duty. But I think requiring employers to take reasonable steps at this stage to prevent harassment before it happens is a really interesting development in our law.
Yeah, it's proactive duty.
Exactly.
And interesting that the duty will be different for different employers, because it depends on your sort of size and administrative resources of the employer, the nature of the working environment, the sector in which they work, and the different risks that employers and their employees, their workforce face in relation to this. So how do employers identify what risks of sexual harassment their workers will face?
There's been a lot of talk, and the EHRC write about it as well in their guidance, that employers should be doing risk assessments in respect of the risks of sexual harassment in their workplace. And I think what's really important when you're carrying out those risk assessments is really tailoring those to your business, thinking about your staff. What are your employees, what are your workers doing on a day-to-day basis, and where do they come into contact with particular risks? Where and why do they come into contact with those particular risks? So although there are various kind of template risk assessments around, I think really ensuring that when you're doing your own risk assessment internally, you are thinking about your staff, your workforce and your business and what they are doing on a day-to-day basis. Are you sending them out to client sites? Are you inviting clients into your offices? Do you have people working on their own in your particular office? Do you have people working from home? Where are the particular flashpoints and the particular risk areas? And I think focusing on not just a sort of generic, how can you stop sexual harassment in society, but focusing on a really specific, how can you stop it in your organisation, is so important for this.
I know that you did a really good thing in our workplace in order to understand what risks our staff might come into contact with, rather than us making assumptions as to where the risks might apply. You undertook a staff survey to get views of different people and what they perceive might be the increased areas of risk, which I thought was really good.
Yeah, and I think it was such an interesting process because obviously we're employment lawyers, we're employment and partnership lawyers. We kind of think we know about this stuff, But actually, where I found the most interesting, what I found the most interesting was just talking to people. We did an online survey, but also I talked to people in the organisation, and just talking to people and what they felt were risk areas, and finding out what specific people felt, where specific people felt they were at specific risk, was a really, really interesting exercise. And I think that is obviously harder to do in an enormous organisation, but I think it's really important that you're just really tailoring that thinking about what your people and what risks they face.
Already you can see that the obligations on employers is quite different than just updating your existing anti-harassment policies in this regard. There are steps that employers need to take. So what other steps can employers take other than properly thinking about their risk assessment?
Well, I think again, it comes down very much to sort of tailoring your thinking on this. So tailoring your policy as well, and obviously updating policies to reflect the new duty, but thinking about and offering training to staff. So those are the kind of the three key steps that lots of people are talking about: is risk assessment, policy, training, and those are all absolutely vital, I think. But when you're in terms of the policy, thinking about not just a sort of no tolerance uh, approach to sexual harassment, but also thinking about what that means in practice. What are you going to do in practice when someone is at an event on an evening and witnesses or is subjected to an act of sexual harassment? What are you, the employer, going to do in that moment if that is reported to you? How are you going to deal with that? Can you offer someone a way to report out of hours? Can you offer staff a way to remove themselves safely from the situation? Can you offer them training, give them tools to manage that in the moment? Can you explain to them how to offer them ways and discuss ways of challenging behavior that is inappropriate, and and offer them training on how to extract themselves from those kinds of those kinds of situations. So it's really thinking about not just putting a policy saying we have a zero tolerance approach to sexual harassment, but thinking about, is there a number they can call? Is there a member of senior management who they can call even out of hours at any time? Is there a do you have a sort of account with a taxi firm who they can get out of situations quickly? What about when they're abroad? Who are they going to contact in those circumstances? Is there someone at the event that you are sending them to who they could contact? What is the policy of the event organizer on sexual harassment? Have they trained their staff appropriately? So and what about third parties who come into your office? Have you thought about cleaning staff, for example? Have you spoken to your contractors about who they're sending into your office and whether they've been trained appropriately? So just thinking about very detailed, literally, what are your people doing on a day-to-day basis, and what are the risks, and how are you going to remove that risk to the extent that you can? Obviously, you can't do everything.
These are really practical steps, Beth, and particularly when we're dealing with third parties and attending events organised by third parties. You mentioned some practical operational questions that we can ask to people who are organising those events or inviting our staff to their events, so we understand what their policies are in relation to sexual harassment. I think that's really important. It's a little bit like challenging your supply chain, I guess.
Yeah, very similar to organisations that have sort of modern slavery, that obligations in relation to modern slavery, looking at your supply chain, looking at where the risks are, and addressing those risks. It's a similar process.
In your view, is this the end of alcohol at events? Because obviously that's always going to be one of the increased risk factors, is when alcohol is present.
Yeah, alcohol plays such a big part in so many incidents of sexual harassment. Not all, but so many incidents of sexual harassment. And I think that is something that employers have been aware of for a long time, and that many employers have been taking steps to, not just for sexual harassment reasons, but also for cultural diversity reasons, to for example, arrange events which aren't focused around drinking alcohol, where drinking alcohol is not the focus. So doing activities, events in the afternoon rather than in the evening. So, trying to manage that risk already. Lots of employers have been taking those kinds of steps Do I think it's the end of alcohol at work events? No, there are lots of people who would like to have a drink after work, who would like to be able to have a drink with their colleagues. I don't think that that is in and of itself problematic. It is when it only becomes problematic when it becomes problematic, really, and that that's hard to judge. But I think that lots of employers will be taking steps to say you have to drink responsibly, or limiting the number of drinks paid for by the organisation. So rather than having a free bar, having a token system where you can get 2 drinks for free, but then you'll have to pay. So I think the days of kind of unlimited shots on tap organised by employers are probably, if not over. They are their days are numbered. But I don't think that I would be surprised to see lots of employers simply banning alcohol at work events.
New generations are just not engaged with alcohol in a way that older generations were. So just to summarise, it's thinking about the risk assessment. If risks are identified, it's thinking about practical steps to react to those risks. It's challenging your events, attendances, conferences, things where your employees or workers are going to be. And then training is going to be a part of it, isn't it? But it's more than just training on what is sexual harassment. It's giving a practical steps to your staff on this is what happens if you experience it or if you witness it.
Absolutely, and I think that training will be really key. But I think it's that the importance of it is the important thing is to make that training really practical, and to ensure that everybody knows how they report and to whom and when.
And presumably, for the people that are being the recipients of reports, potentially they need to understand what their duties are in those situations.
Absolutely.
I've got a couple of examples actually that are in my head of instances where sexual harassment may have occurred. So one would be where you have an individual who is at a work event, which is off-site, and they experience sexual harassment, and where there are colleagues at that event who may be more senior to them, they're able to speak up immediately to that colleague to get that protection. The colleague who receives the report at the event, what would you recommend that they might consider doing? What would your training to them say?
I think obviously it will be massively dependent on the nature of the event, but I think the key thing is to try and offer support to the person who's made the report, try and remove them safely from the situation as quickly and efficiently as you can, whether that's arranging for them to get a taxi home, whether that, whatever that looks like in the moment and depending on where you are, but offering them support. If it is safe and feasible to do so, I think challenging the behaviour, finding out who the alleged perpetrator is and the organisation for whom they work, so that you can take steps, if not in the moment, you can take steps after the event to deal with that particular behaviour. But really the priority for a report in that moment is the safety of the person who's made the report to you and others involved in the incident.
Thank you. And then the other example I've got in my head is where your risk assessment throws up that at a previous event where the employer has partnered with a third party to run something, and your risk assessment throws up that at a previous event the third party has sexually harassed a member of your staff. So you're aware that there is an increased risk that if you partner with this third party again, that it could happen again if that harassment at the time wasn't properly dealt with. What do you think about that situation?
My first response would be, why are we partnering? If there is a risk, why are we partnering with this organisation? And I think that would be the first thing you'd look at, if it's appropriate at all. If for some reason, it's if for some reason that is not sort of fixable, then taking steps and corresponding, communicating with the partner to make clear that your staff have an entitlement to work in a safe environment free from sexual harassment, and that you and your approach in terms of zero tolerance. So I think communications with that third party, but I think employers will need to be braver about saying this may be a big financial opportunity for us, but we are not going to take that financial opportunity if it involves putting our staff at risk. And that includes terminating retainers with clients. I think if they behave inappropriately towards your staff, I think employers will have to be, to show that they've complied with this duty, will have to be braver about taking those kinds of steps.
Thank you. I think that word being braver is properly summarises actually the employer's duties under this legislation. Thank you, Beth. I've really enjoyed talking to you about this, and I think there's probably more 10-minute talks that we're going to that will come along as a result.
Yeah, so interesting. Thanks, Emma.
You're welcome.